Folks, when I gave you the preliminary instructions, I advised you that the parties may stipulate that certain facts are true, and that stipulation, also known as an agreement, if there was one, I would let you know about it, and that if there was a stipulation, you must accept those facts as true in this trial. And it has come to pass, thank you to the professionalism of the attorney, that there is one, and I'm going to tell you about it right now. Okay? The parties stipulate to the following facts regarding court exhibits numbers 119 and 135. Based on a prior agreement of the parties, plaintiff Stacy McKenzie, through her counsel, provided an electronic copy of her entire Facebook account to Mr. Bill Kammer, a data recovery expert. From the electronic copy of the plaintiff's Facebook account, Mr. Kammer provided to counsel for the defendants in this case, Mr. Filner and the city, only those Facebook pages containing posts that were created after April 21, 2013. Court Exhibit 119 includes such Facebook posts. Mr. Kammer also recovered data files from the electronic copy of plaintiff's Facebook account. Exhibit 135 includes copies of posts and photographs from those data files. The dates that appear immediately below the photographs appearing in Exhibit 135 are dates of the folders expressed in computer time, not the dates the photographs were actually taken. The dates the photographs appearing at Exhibits 135-004 and 135-005 were actually taken is February 12, 2013, Mardi Gras. All right, that then is the agreement of the parties with regard to those matters. You must accept those matters as true in this trial. Now, Madam Clerk, I'm going to ask that you file stamp this stipulation. Ladies and gentlemen, this will be included in the notebook that has the jury instructions and the form of special verdict. You'll be able to read it again at that time. Okay? All right, ladies and gentlemen, thanks for your attention. We left off yesterday with Ms. Ramirez being cross-examined, and we'll pick up at that point.
I want to bring to the attention one paragraph of the error in stipulation, or paragraph 4, the date is February 12, 2015, not 2013. Marty Gras.
You see that? Okay, cross resume, please.
Yes, sir. Yes, sir. Thank you.
Ms. Ramirez.
Good morning.
Now, I want to take you back to your testimony yesterday about the declaration that you arranged to have Ms. McKenzie sign. Remember that testimony?
Yes.
Now, you sent her an email that enclosed the declaration that you wanted her to sign, correct?
Correct.
Okay. I want to, may I approach her?
Yes, by all means.
I want to show you what I will have marked next in order as exhibit number 77. It's redacted because of the email chain, but it purports to be the email that you sent to Ms. McKenzie on August 19th, 2013. You see that, ma'am?
Yes.
And is this the email that you sent to Ms. McKenzie on August 19, 2013, which enclosed the declaration that you wanted her to sign?
Yes.
Okay. Move to admit exhibit number 77.
Any objection?
No, Your Honor.
77 is received.
May I show this on the screen?
By all means.
Okay, this is the essence of Mr. Schaefer's boss, correct?
Yes.
And Mr. Jan Goldsmith is the attorney in this case, correct?
I'm not sure I understand what you're asking.
May I approach, Your Honor? I want to show you a document that I would ask you to review to see if it refreshes your recollection. This document purports to be a declaration of Mr. George Schaefer, and it has a list of the attorneys that represent Mr. Robert Filner in the city of San Diego. Do you see that?
Yes.
Does that refresh your recollection that Mr. Jan Goldsmith is the attorney in this case, as well as Mr. Schaefer?
An investigation. I will oftentimes begin an investigation before a complaint is filed.
Okay, all right. Bear with me. Now, was it correct that at the time that you arranged to have Ms. McCormick sign the declaration that that the city attorney wanted to use the declaration in the McCormick case? Is that what you were? Was that your understanding?
Objection. This states in testimony, Ms. McCormick did not sign the declaration.
Go ahead.
I don't know what case the declaration of Stacey McKenzie was going to be used in. I was inundated with investigating the McCormick Jackson allegations. So I knew that I was asked to have the declaration signed. It was a side task that was given to me. I did not know what case it was going to be filed in, just that it was going to be filed in a case that we were working on related to the matters.
Okay, all right. When you say that you were inundated with the allegations of the McCormick case, you understood that the lawsuit had already been filed, correct?
I did not. I understood that there was a media conference and that rose issues that we were then beginning to investigate.
Okay.
I don't remember at what point in the process of the investigation I conducted this investigation, whether the complaint was filed or not.
All right, okay. Is it, to your knowledge, was it unusual that the declaration that you arranged to have Ms. McCormick sign didn't have a caption on it? You know what a caption is?
Objection, Your Honor. This states the testimony. Ms. McCormick did not sign
Okay,
it.
I don't need argument unless I ask for it. The objection is overruled. You may answer.
When I'm asked to get a signature on a declaration, it is often a portion of the declaration because it's not formatted by the secretary. There's many pieces and parts, I guess you could say, that go into the completion of a declaration. So when an attorney sends me a Word document with the declaration, asking that I have the person review it and obtain a signature, it's not at all unusual that it's in a draft form such as this.
Okay, but it wasn't a draft form that you sent Ms. McCormick in your email, correct? You sent her the declaration and asked her to sign it.
No,
Now,
it-
you keep saying McCormick.
You know, I apologize.
That's the third time.
Yes, Your Honor, thank you.
I think the jury understands it from context, but you really need to get the names right.
Yes, Your Honor, that's correct. I apologize. When you sent the declaration of McKenzie to Ms. McKenzie, is it correct that the declaration was in the format that you wanted her to sign?
That is incorrect. It is a draft form, which is why we ask people to look it over for correctness and completeness. And if anything is factually incorrect, to contact me.
Okay, if you look at exhibit number 74, you have it in front of you.
Yes.
Exhibit number 74 does not have a caption on it, correct?
Correct.
And that's the declaration that Ms. McKenzie signed, correct?
That is correct.
And that declaration is the same as the declaration that you attached to your email to Ms. McCormick. You can look at your email if you wish. And the question is that correct?
That is correct.
Okay. So there was no caption on the declaration that you sent Ms. McKenzie, and there was no caption on the declaration that Ms. McKenzie signed, correct?
Correct.
All right. So, is it correct that you understood that the city attorney wanted to use Ms. McKenzie's declaration to defend itself against Ms. McKenzie for her claims against the city and Mr. Bob Filner? Was that correct?
Question's unintelligible.
Yes, Your Honor. I'll rephrase. Is it correct that you understood that the city attorney's office wanted to use the declaration to defend against claims made by Ms. McKenzie against Bob Filner and the city of San Diego? Was that your understanding?
No.
Is it correct that if the city attorney's office wanted to use a declaration in the McCormick case, there would be a caption that said Irene McCormick versus the city of San Diego and the declaration on the caption, correct?
Not necessarily.
Okay. You saw the declaration that I gave you that Mr. Schaefer signed in this case, correct? Did I just show you?
I don't know that I have a declaration that Mr. Schaefer signed here.
May I approach again, Your Honor?
Of course.
I showed you this, ma'am, declaration of Mr. Schaefer. In
Yes.
this case, okay, that has a caption on it, correct?
Yes.
It has a caption on it because it relates to this case, correct?
Yes.
And there was no caption on Ms. McKenzie's declaration that related to any case at all, correct?
Yes, but I
Yeah,
don't
that
know
means
how it
yes or
was
no? Yes or no?
filed. Yes.
Okay, and that's because you understood the city wanted to use that declaration against Ms. McKenzie in this case, in
That
the
is-
event that she filed a lawsuit, correct?
No.
Now, when you were performing your investigation as an investigator, you weren't investigating a sexual harassment claim like an EEOC investigator or something of that nature, correct?
We were investigating allegations of sexual harassment, but I'm not an EEO investigator.
When you were performing the investigation, you did not submit your findings to an HR person at the City of San Diego, correct? A human resource person, correct?
I don't reach findings.
Say again?
I do not reach findings.
Okay, you didn't submit the information that you obtained from Ms. McKenzie to the Human Resource Department, correct?
That's correct.
And you understood that there was a Human Resource Department that investigated allegations of sexual harassment in the workplace at the City of San Diego, correct?
Yes, there is.
Instead, you submitted the information that you received from Ms. McKenzie to the attorneys in this case, George Schaefer, Jan Goldsmith, and Ms. Sloppy, correct?
Yes.
Okay, one final question. In the declaration of Ms. McKenzie, final couple of questions if there's follow-up. Look at paragraph 5 of the declaration. The last couple of sentences says, and he said that he was going to be mentoring me and he'd like to get close to his employees. You see that? Exhibit number 74. You see that, ma'am, in her declaration?
Yes.
Very bottom, you see that?
Yes.
Okay. He'd like to get close to his employees. In your memo, to Jan Goldsmith, Mr. Schaefer, and Ms. Slotnick and others, on page 2, you characterize that as, on the top of the page, he liked to get really close, correct? See that on the top of the page? He liked to get really close to his employees.
Yes.
In fact, Ms. McKenzie told you that he used the word really close in a sexual way, didn't she?
I do not recall that.
And that doesn't appear in the declaration because the city attorney wanted to water that down so it didn't appear to be sexual in nature, correct?
I don't know what the purpose is. I didn't write it.
Thank you. No further questions.
Reader,
Good morning, Ms. Ramirez.
Good morning.
Mr. Corrales made the statement that this email, which has been marked as number 151, was sent to Mr. Goldsmith, Ms. Slotnick, and myself, and others. Could you tell the ladies and gentlemen of the jury who these others are?
Investigators within the Civil Division.
And could you identify who those people are?
David Johnson, Louis Roberts, Dan Andrews, and Rodney Edelheit.
And were there other attorneys within the city attorney's office, if you look at the 2 line, who were also sent this email by you?
Yes.
Who were the other attorneys?
Paul Cooper, Andrew Jones, and Kathy Steinman.
So, to recap, the email that you sent was just not to Ms. Slotnick and myself, and the city attorney, is that correct?
That is correct.
And there was mention of the fact that there was this McCormick Jackson matter. Did you know who Ms. Jackson's attorney was at that time?
I believe so, yes.
Who was that lawyer?
Gloria Allred.
Did you have any indication when you met with Ms. McKenzie on August 9, 2015, that she had a lawyer?
No.
Did you have any indication when you met with Ms. McKenzie on August 9, 2013, that she was intending to file a lawsuit?
No.
Did she ever mention to you, by the way, I'm going to be filing a lawsuit?
No.
If you had known that she had counsel who was contemplating filing a lawsuit related to sexual harassment, would you have contacted her without talking to the lawyer?
Objection, leading suggestion.
Overruled, you may answer.
No, I would not.
Why not?
Because in that instance, we would need to contact the counsel to contact their client.
Is that a matter of ethics?
Yes.
Now, there was much made about the fact there's no caption on the top of Exhibit 74, the actual declaration. Have you seen in litigation cases pending where there are a group of declarations all filed as one with only one caption on the first one?
Yes.
Is that uncommon?
No.
No other questions, Your Honor?
Any recross?
Just briefly, Your Honor. In fact, Ms. Ramirez, the declaration that you arranged to have Ms. McKenzie sign was never used in the Irene McCormick case, correct?
I do not know.
At the time that you interviewed Ms. McCormick, you never told her.
Might as well just start over now.
Sorry, Your Honor. At the time that you interviewed Ms. McCormick, you never told her.
Right two.
Oh, I'm sorry. Yes, it's bad wording, Your Honor. I apologize. At the time that you interviewed Ms. McKenzie, you did not tell her that she had the right to have a lawyer look at the declaration before she signed it. Is that correct?
You're meshing two events together that don't allow me to properly answer the question.
Let me rephrase the question. At the time that you interviewed Ms. McCormick, excuse me, at the time you interviewed Ms. McKenzie, you did not tell her that she had the right to have a lawyer represent her, correct?
That's correct.
And at the time that you sent the email to Ms. McKenzie, you did not tell her that she had a right to have a lawyer assist her in reviewing the declaration before she signed it. Is that correct?
That's correct.
Thank you.
Anything further, Mr. Schaefer?
On that last point, why did you not tell Ms. McKenzie, either when you met with her or when you talked to her, that she had the right to a lawyer?
It's a commonly known fact that you have a right to counsel if you'd like to begin a case. I had no understanding that she was going to begin a case.
Thank you, Your Honor. No questions.
May the witness be excused.
Yes, Your Honor.
Thanks, ma'am. You are free to return to your duties. Next witness, please, Mr. Schaefer.
The defendant's called Dr. Dominic Dario.
Dr. Dario, please, deputy.
Please right hand be sworn. In the matter now pending before this court, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Thank you.
Please state and spell your name for the record.
Dominic Adario, D-O-M-I-N-I-C-K, last name A-D-D-A-R-I-O.
Okay. Mr. Schaefer, you may examine Dr. Dario.
Yes, Your Honor. Dr. Dario, what is your occupation?
I'm a physician licensed in the state of California, and I have a specialty of psychiatry.
Dr. Dario, I'd like you to look at Court Exhibit 131, which has not yet been received into evidence. Do you recognize that document?
Yes, that's a copy of my resume or curriculum vitae.
And is that the current curriculum vitae for you?
Yes.
Your Honor, if you save time off of that in evidence.
Sustained on hearsay ground.
All right.
You may elicit the information here in open court, however.
I will. Dr. Dario, could you just tell the ladies and gentlemen of the jury the different areas that you have licenses in?
Sure. As I said, I'm licensed as a physician, and I'm also board certified by the American Board of Psychiatry and Neurology in Psychiatry. I can tell you about my training and background if you want.
I was going to get to that next. What is your training background?
I went to Rutgers University. I got a bachelor's degree there. I was a Rutgers scholar on a full scholarship. I then got a medical school scholarship from the Robert Wood Johnson Foundation. Sorry about that. And I went to Wake Forest University School of Medicine. After that, I took a year of medicine surgery internship at Albany Medical Center, a year of psychiatric residency, and then I served 2 years as a lieutenant commander at Naval Hospital San Diego in psychiatry. Following that, I finished the additional 2 years of psychiatric training at University of California, San Diego in 1975, and I've remained here since then. I also had some additional fellowship work in London and also the Salk Institute.
Do you have any current positions within any of the fields you mentioned at this time?
Current positions?
Yes.
As in psychiatry, I have a clinical professor position at UCSD, which I've held a full professor for 25 years, and I've taught there for 35 years. I teach courses in brain injury, geriatrics, and also in legal issues, forensic psychiatry.
Are you considered a qualified medical examiner?
Yes, the state of California has a special test you have to pass to evaluate disability and causation of issues, and I passed that, and I've served 90% of the time as what's called an agreed medical examiner, where both sides in work injuries would pick you to provide a single report. I'm also an examiner for the Medical Board of California to examine physicians with problems, and I'm also on the board of the evaluator for the Nursing Board of California. I've done for both.
Are you a member of any professional societies?
Yes, a good number. I'm a emeritus member of the American Psychiatric Association. I'm also a member of the American Association for Legal Medicine and a number of other organizations as well, including Rotary.
You mentioned your educational background. Have you received any awards?
Yes, I have. I've gotten some research awards in medical school, and I received an award from the state of California, the legislature, for distinguished work. I also won the Best Teacher of the Year award from UCSD one year.
And have you published any professional articles in the field of psychiatry?
Yes, I've published on the area of depression, anxiety, some work in dementia because I have an interest in the aging and also brain problems. I have 2 books in psychopharmacology, case studies, that look at how medications should be used.
And have you lectured in any of these areas at any time?
Yes, I don't lecture as much as I used to, but I used to lecture a great deal at different places, University of Washington, UCLA, Tulane, other places I've given lectures at on various subjects.
Have you ever testified before as an expert?
Yes, I have.
And in what fields of expertise?
In my field of psychiatry, excuse me.
And can you tell us how many times approximately did you know?
I've probably been deposed in terms of depositions, testimony, maybe 300 to 400 times, and in terms of court appearances, maybe 70 to 80 times in court itself. That's federal court and state court.
Have you been retained in civil lawsuits
Yes, I have.
by plaintiffs and defendants?
Yes, both sides. It's pretty even, about 45% plaintiff and 55% defense.
Were you retained by the defense in this case?
Yes, I was.
And what was your understanding as to why you were retained?
There were claims of psychological and psychiatric injury, and as a consequence, there was a request to do an examination to see if Ms. McKenzie had, in fact, either developed the psychiatric condition as a result of stressors that she associated with a meeting with Mr. Filner, or if any of the conditions that she had pre-existing, mental problems that she had prior, might have been aggravated by the stress of that interaction.
And by the interaction, Mr. Filner, are you referring to the interaction that took place on April 21st, 2013 at Balboa Park?
Yes, it's one single time that she met him on the 21st of April, 2013.
Now, you said Balboa Park, but you meant Mission Bay.
Mission Bay Park.
That was my understanding, too, Mission Bay.
Before you met with her and performed an independent medical exam, were you provided any materials to assist you in understanding this case?
Yes, I had extensive records prior to seeing her.
And did you prepare a report that would assist you in just listing the different materials that you did review?
Yes.
Could you tell the ladies and gentlemen of the jury, and if you need to refresh your recollection with the report, what materials you were provided that you reviewed?
Yes, I read a total of approximately 5,000 pages of records and materials, the most important of which would be her medical records from Sharp Reese Steely Medical Group Outpatient Care. And that went over the course of 12 years from June 10, 2003 up until May 11, 2015. That was about 3,000 pages of medical records. I read Dr. Breffney Barrett, psychologist's evaluation, and his records as well in testing. And then I read a number of, I have about 30 items here of various exchange of information, complaints, U.S. Equal Employment Opportunity Commission records, U.S. Department of Justice. I read a number of depositions, Vincent Hall, Donna Fry, Stephen Hadley, Ms. McKenzie's deposition, Dr. Barrett's deposition. I also read court testimony of Dr. Barrett and the transcript of my examination, which I taped with Ms. McKenzie's approval to document the evaluation and to refresh my memory as to what we talked about.
And did you have an opportunity to review a transcript of Ms. McKenzie's testimony in this trial?
Correct.
And did you have an opportunity to look at some Facebook posts that were made exhibits in this case?
Yes, I had just received those a few days ago.
Did you have most of this information before you met with Ms. McKenzie?
Yes.
And what is the importance of having so many medical records?
Well, in medical legal matters, you're doing a forensic evaluation. So in a clinical evaluation, someone is simply coming to you for help, and there's no complicating factors. There's no litigation. There's no issues that might arise from that affecting what they have to say. Also, there may be issues in the person's life that go back many years that they don't have a clear recollection of. Or other people may say things that are going to be different than the person you're examining. So you want to look at all those things to get the clearest view of what the whole picture is. That's why in forensic evaluations, the records are very critical.
Do you think if you were to be able to competently render an opinion in this case, that just looking at 50 pages of medical records would have sufficed?
I would have requested the entire medical records if they were available, which I did, to you when you discussed the case with me.
Now, when did you actually meet with the plaintiff, Stacey McKenzie, for this independent medical exam?
I met with her in my office on October 16th, 2015.
And before we talk about that, what overall, looking at all these records that you studied, can you summarize what you found from a general standpoint?
From the medical records, I found that she had had a clear and definitive pre-existing psychiatric condition for which she had received regular ongoing supervision and treatment from her primary care provider, Dr. Jennifer Luang, in conjunction with multiple orthopedic problems and many years of need for narcotic medications. The orthopedic problems involved a degenerative and injured shoulder, which she shared with me most likely would need a shoulder replacement eventually, and then also an ankle injury. And the records from 2003 forward had a diagnosis of anxiety primarily, an obsessive compulsive disorder where she was preoccupied with details to the point where she could become ruminative about them, and that she had been receiving successful treatment in the form of medications. I noted that, and most importantly, that for years prior to the episode on 4/21/13 where she met Filner, and for the entire time after, in the records I reviewed, which would have been another year and a half or so, there had been zero change in her medications for psychiatric reasons. So the antidepressants she was on, the anti-anxiety medications, those doses stayed the same. And that would suggest there was no change in her mental condition. Also, there were, on every occasion, the notes read stable in terms of her mental state. So I didn't see any change in her mental state from the records.
When you met with her, and we'll come back to the medical records in a little bit, did you conduct any tests? We had testimony Dr. Barrett, he did. I'm wondering if you did.
I did conduct psychological testing, as I normally do.
I don't want to get too down into the weeds, but what type of tests did you perform?
Three different profiles. The first is what we call self-reporting tests. These are such as the Beck Depression Inventory, the Beck Anxiety, the Zung. They're nothing more than a list of 21 complaints that you might have if you have anxiety, 20-something complaints if you have depression. And this gives the patient in their own hand a chance to mark off what are the symptoms that they're suffering from, so you don't miss anything and you're very thorough in asking those questions. But it's subjective. A patient can make themselves look as bad as they want or as healthy as they want. I give two tests that are objective, and those are the MMPI, the Minnesota Multiphasic Personality Inventory. And that test tests depression, anxiety. It also has validity scales in it. And it looks at personality profile as well. And then that's 566 questions. And also the MCMI3, which is 175 questions, that looks at similar issues. Those tests also have very good parameters for assessing post-traumatic stress disorder, which is an issue in this case if she had any traumas that caused stress or aggravated her anxiety. And those are the tests that I used.
And we'll come back to the test that Dr. Barrett administered later on. But there a particular reason that you didn't use the test, all of the tests that he used?
Yes.
What is that?
Well, he used minimal tests. He used the Beck Depression Inventory. If he had the records I had, he would note that her primary treatment problems were for anxiety as well as depression. So he should have tested both anxiety with the Beck as well as depression. Secondly, it's a forensic case. It's a medical legal case. You want to use the most well-established, solid statistical testing that you can use. He used a trauma test, which is called the traumatic TSI, Traumatic Symptom Inventory 2. That test has just been out since 2010. The TSI-1 goes back to 1995, but I don't feel it has enough statistical basis to be used for forensics. It's fine for PTSD screening, such as the VA. I developed with a psychologist the traumatic event sequelae inventory, which has been used on 64,000 people and is a test that they use at Fort Hood for returning veterans having to do with PTSD. But these are screening tests. That's why I use the MMPI-2. It's a much more in-depth test. What is important about the testing, if you want to talk now about the conclusions, I can do that.
That was the question. What did the test you gave?
The board on my tests, meaning the MCMI, Barrett's test, the traumatic inventory symptom evidence of post-traumatic stress disorder or trauma. So none of her psychological testing that's objective testing would support that she was suffering from trauma. It would support that she was suffering from ongoing anxiety.
Why did you feel it necessary to also interview Ms. McKenzie?
Well, the testing is maybe 10 or 15, 20% of it. Records are very important. They vary from 20 to 40% of your impression. But you need to talk to the patient about what they've been through. When it has to do with trauma, you also want to see their emotional reaction when they discuss the issues, and discuss with them how they're feeling now and what they may have done over the years since the trauma resolved.
Did you tape record the interview?
Yes, I do that in all cases with the patient's permission.
So Ms. McKenzie was aware of that?
Yes.
And what did she tell you during this patient interview as what happened when she was encountered Mr. Filner at Mission Bay Park?
Well, I think in essence she was very shocked and surprised by his behavior. She saw him as being odd. She described him in various terms, creepy. She thought he could be senile. She thought he was suffering from some kind of a problem. And there were sort of two interactions. The first one was when he asked her for a date and held her hands or wrists. And that was an interaction she described as mild compared to the second interaction when she was with two park rangers and he came over, and she describes him putting his arm around her head and touching her shoulder and possibly the side of her chest and breast with his arm, not his hand.
From that interview, was there anything that was particularly striking to you in terms of how she described it?
Yes, there were some contradictions. She described it as being a person who is with the person of authority, and that person of authority is forward, and she's kind of shocked by how he's behaving. On the other hand, there were some contradictions, as I said. For instance, after the first episode where he grabbed her wrists and asked her for a date, she did share in that first episode personal information. For instance, she said she was aware that he was engaged, so she knew something about him personally and his marital status. She did offer, when he asked her, that she was divorced. And she did give her card. She said this was because she felt intimidated that he was the mayor, so she was much more compliant than she might be with somebody else, which is understandable. When she went over to her friends who were park rangers and police authorities, I thought it was of interest. She said to them, "You won't believe what just happened to me. The mayor asked me, Filner asked me for a date," which I thought was strange. It wasn't that he assaulted me or he did some things to me or something's really strange, but that was what she said to me in the interview. And it was her intent, however, to leave. She said that after the first part of it, she wanted to get out of there and go get her son, who was in a play area, and leave, but she didn't. She went over to these two park rangers who were friends and talked with them because I guess she ran into them on the way out.
And from what she described to you, did you have any concerns about how the park rangers reacted to this in terms of her version of what happened?
Well, from her version, I think she described them as her friends, the park rangers, as being shocked by the mayor putting his arm inappropriately around her head and rubbing her arm, and then saying very complimentary things like he was going to make her the employee of the month. But the park rangers sort of played along with it. They said, yeah, that's good, or something to that effect, you know, promoting her skills and abilities because she's a good worker. So that was the scene that evolved. I was struck by the fact that if it looked like she was being assaulted, you would think that the park rangers would have also taken action and done something.
Sustained, and the testimony is stricken.
May I clarify the entire testimony, Your Honor, or just that last part?
The entire response, which was not responsive to your question. Okay, let's go. Jury is ordered to disregard the entire last response.
What is the significance of what she told you in forming your opinion in this case about whether she suffered any type of emotional trauma, about what she described in reference to the park rangers?
I don't think she had any trauma relative to the park rangers. The trauma would have come from Filner's behavior.
In forming your opinion, was it important to know what she was describing in terms of the park rangers' reaction?
Only in that they didn't take action in seeing her as being assaulted. That would be the only comment.
Fair enough. We had testimony at trial in this case by Ms. McKenzie that the incident where she was embraced, however you want to describe it, was 8 to 10 seconds. What did she tell you about the timing?
She said a couple of things. She said she felt like forever. She also said to me that it was 2, 3 to 4 minutes was her quote. So 2 to 4 minutes is what she described. She did not use 8 to 10 seconds.
Is that a significant fact to note?
Well, it's a big difference between being grabbed and held for 2 to 4 minutes and 8 seconds, so there was some difference there.
Now, you were describing earlier how she made mention of the fact of her perception that perhaps Mr. Filner was senile, had mental health issues. Is that significant anyway?
Yes, she felt he was odd, that this was not only peculiar behavior, but there was something wrong with him, that he was not either himself or acting in a normal manner, that something else was going on.
Did she tell you how at one point she started blushing? Mr. Filner noticed that she was blushing, made a statement about her being embarrassed, and then Mr. Filner let go and left?
Yes, that's precisely how she described it. Once he noticed she was blushing, he disengaged and never saw her again.
Is that significant to you in this case?
It's significant in that at that point he may have for the first time realized that he was making her very uncomfortable and then exited. So that's the only conclusion I can make from her description.
Now, have you had, during your career, your forensic career, sexual harassment cases, employment cases?
Yes, I've evaluated many of them.
And from your experience in this area, was the conduct that she described consistent with a perpetrator of sexual harassment in terms of their profile?
In the workplace, it's not. There are many differences in this particular issue.
Objection, Your Honor.
Grounds.
Non-responsive, he had it in the workplace.
Sustained.
In the workplace, is that consistent with what you have observed in these other sexual harassment cases?
Objection, Your Honor.
Sustained. You're asking questions outside the field of expertise of the expert. Sustained on that basis. Let's get back and stipulated.
In sexual harassment cases, when you're trying to gauge the extent, if any, that a sexual harassment complainant has suffered trauma, what do you look for in terms of the actual event, the interaction with the alleged harassment?
Well, it is usually a supervisor that directly supervises the person, or a coworker who has regular ongoing contact with them, has the desk next to them, has the office across the way, goes to work with them, and it's over an extended course of time.
Objection, Your Honor. Also non-responsive.
Sustained.
Ms. McKenzie made reference to the fact that, from her perception, Mr. Filner appeared dangerous at that time. Is that something that you found from her description, based on your experience in these types of cases, was found?
I don't know if she was, she didn't describe herself as being physically frightened as much as she was frightened by his authority and not wanting to cause a problem that might affect her employment. I think that was her general feeling in her discussion with me.
Is there anything that, from a psychological standpoint, makes sexual harassment more stressful?
Yes.
What are the factors that you look for in making that determination, whether conduct that's characterized as sexual harassment is stressful?
Well, when the person is put in a position where there's a demand for quid pro quo sex, namely, if you want your job, you have to date me.
Objection, Your Honor. Non-responsive, it's irrelevant to the case.
You may continue.
Where there's authority on a regular basis over your job or a coworker, and there is continued demands placed on you with a direct threat, and then there are events that take place. If you don't do what they want, your workload may change. Someone else may be promoted who has less experience than you. Or you may be found to be deficient because they start micromanaging you and finding complaints about you that they never had before. And it's being promoted out of a need to bend your will to their sexual needs. That is the typical profile of sexual harassment in the workplace.
And did you find any of that in this case?
No. In fact, I found the opposite.
Objection, Your Honor.
What did you find?
Wait for the next question.
What did you find on that issue?
Well, you look for the employers and the employer's authorities to be unsupportive and critical of a person. They get into cahoots with the perpetrator. That was not the case here. The human resources person, Ruiz, was highly supportive and kindly to her, and there was no problems with that. She had a friend of 20 years who was her superior, Miss Lomedico, who she described as a great lady, who said she would be supportive to her through the whole process. And there was no evidence that people that supported her were in any way punished for it. She told me that Ms. Lomedico has been since, I don't know if she told me or if it was from her deposition, that Ms. Lomedico has been made now Chief Financial Officer, Assistant Chief Financial Officer for the city. So she had all the people of a direct authority over her were kindly and supportive of her. No one criticized her. And that's not typical of what you see in sexual harassment cases.
Were you aware from talking to her or from the information provided that she, at the time of this incident, there at Mission Bay Park, was a management employee?
Yes, she had 67 employees that she managed.
Is that significant to you in determining whether she suffered any emotional distress from the incident?
Yes.
Why is that?
Well, she was in a position of authority herself. She had extensive experience in management, and that would demand that she understand the issues that have to do with sexual harassment. She had handled employees, hired and fired them, and in fact had fired employees where there was inappropriate sexual behavior in the workplace. So she was not naive to the process, and she knew how to work within the system.
We've had testimony in this case that Ms. McKenzie submitted to a radio show interview, media interviews. Is that significant in your analysis in determining whether she suffered any type of stress?
Yes.
Why is that?
Well, Dr. Barrett presents a psychological formulation which I don't agree with, which is one that she was in denial.
He didn't ask you about Dr. Barrett.
I have respect.
He asked you about whether it's significant or not.
Well, it
Let's
would.
come back around to the question, shall we?
Yes, sir.
Why is that significant?
It's significant because if you want to minimize or deny a situation or frightened of losing your job, it's unusual that you would go on the media revealing everything that happened to you. There's a contradiction there. I think she was motivated because she wanted to support others who had come forward. But if you're in denial and you don't want to be known, so to speak, it's an unusual behavior.
Now let's come back to the medical records. You gave us an overview about her records, about the medication, the patients. Was there any mention in the records about stress caused by what happened on April 21, 2013 with Mr. Filner and the plaintiff here?
I'm sorry, can you repeat the question?
In these records, was there any reference to this incident involving Mr. Filner?
No, there was one entry in the Sharp Reese Staley Medical Group records of approximately 60 entries over the course of 12 years. And that was an entry on 12/19/14, and it was a note from Ms. McKenzie to Dr. LeWang. It wasn't a visit. And I have what she wrote in that note.
Okay, wait a minute. I just need to update this. If you could look at Court Exhibit 152, which has not been received into evidence, is that the note that you're referring to?
Yes.
You're going to offer that into evidence?
Objection, that's hearsay.
Your Honor, I thought we had a stipulation.
Okay, just what's your response to the hearsay?
Your Honor,
Is it a note from the plaintiff to the physician?
I can set the foundation further.
Why don't you lay a foundation?
What is your understanding as to what this note is?
It is a note that says sender Stacy McKenzie, and
Not hearsay then, is it?
Mr. Mitchell, are you withdrawing your hearsay objection?
No, because I don't have that exhibit.
Get it straight, fellas. Come on.
No, we're not withdrawing our objection because I think I would want to say more right now based on what this says.
Go ahead with your foundation.
In your review of the records, did it indicate it's from Ms. McKenzie?
Yes, it's entitled FMH Communication, and it says sender Stacy McKenzie, and the content appears to be a patient's description of issues to her doctor. It starts.
What is the date of that?
The date of that is, it says sent 12/18/14, and also it says sent 12/19/14.
Your Honor, having set the foundation for I offer the evidence.
Any objection?
No objection.
It is received.
Ms. Martin, if you could please put that on the screen.
Ms. Martin has magnified on the screen what you just described. Is that correct? The date that this was sent?
That's the one of the two headings, yes.
And if maybe we could show the other heading just so we have a complete picture of the document for the jury.
Correct, that's the second heading, below which is the note.
And if we could magnify the note, and the jurors can actually read that themselves. And just give them a couple minutes to read it. And then I'll ask you that particular thing in that note. One of the jurors, Ms. Martin, wants it further magnified.
As big as it can get.
Okay.
Okay. All of the exhibits will be in a binder for you folks. You can read them to your heart's content in the jury room.
Just so the jury has as much information as possible at this time, what was your understanding as to what was...
Objection to that last part there, just so the jury knows.
The objection lacks merit and is overruled. Continue with your questioning. Let's go. Let's get this rolling. Come on.
Did Ms. McKenzie ask for any type of prescription?
Yes, she had prescriptions.
And what prescription did she ask for?
She asked for narcotics for pain.
What was the name of the medication?
Norco.
From your recollection from previous records, was this the type of medication that had been given before?
Yes, she'd been on it long term.
And what did she say, if anything, of significance in this record?
Well, this is she said in this entry of significance, I have been really anxious and stressed. This is the second sentence. Dash, it is a combination of holidays with limited money and this Bob Filner lawsuit. So she describes stress as two specific items. This is the only mention of the Bob Filner lawsuit in any of the medical records.
And why is that significant?
Because if her anxiety was worse as a result of the interaction with Mr. Filner for any extended period of time beyond, say, a few weeks where she felt upset by it, you would expect her to begin to talk to her doctor about it. You would expect at least a few months after it occurred, or at least weeks after it occurred, you would expect that she would have talked to the doctor saying, my anxiety's worse and can you refer me for counseling? That would be typical of what you would see in a medical record if someone's problems get worse.
Do you know whether Sharp has the ability to refer patients to counseling?
Yes.
How do you know that?
They have affiliations with psychiatric treatment programs such as Psych Centers of San Diego. So if a primary care doctor feels a person needs counseling or the expertise of a psychiatrist, they'll refer to that program.
Now, there's mention in here about a combination of stress, holidays with limited money. Is that significant?
Only in that it speaks for itself, that there were financial stress.
Is the stress involved from a lawsuit the type of stress that you attribute to the stress of the underlying incident that led to a lawsuit?
No, I think that the stress from the incident would have resolved itself within a few months. She was upset clearly by his behavior, and then she had some fears about losing her job, but he never contacted her. There was no threat to her job per se, and he left his employment having any influence over her as of August of the same year, 5 months later, 5 months later. So for her to continue to have stress a year, 2 years out, I could not find a cause other than the litigation issues.
Did you, in reviewing all of the information in this case, find whether there were, and you can turn that off this moment, any other stressors in Ms. McKenzie's life that were important in reaching your opinions in this case?
Yes.
What were those stressors?
Those stressors were ongoing pain problems with shoulder and ankle and need for long-term, over numbers of years, narcotic medications to cope with the pain. Pain is very unsettling and troubling. Extended child care responsibilities as a single parent, which is very demanding on a person. And she had an 8-year-old child for which she was solely the parent, and a 17-year-old, 16-year-old who she shared parent responsibilities with an ex-husband. So those would have been sources of ongoing demand and stress for her. In addition to the work demands of supervising 67 people and having a very highly responsible job.
Did she ever mention anything about any automobile accidents?
She had a motor vehicle accident, 2 of them, a more serious one in which she had injuries in August of 2014, a year plus after the incident, and then a minor accident where she said she had no injuries approximately 6 or 8 months later.
Is that important?
The one with injuries is because it would have aggravated her pain problems, at least for a period of time.
Was the medication that she was receiving for pain, was that appropriate or was that an issue at all?
I feel it's appropriate. They have MRI studies, x-rays, there's objective evidence that she has pain from that.
Did you ever find any indication in the notes that you had a dependency on medications?
No. There were suggestions they wanted her to cut back at times, try to use less, but that's typical of good doctor-patient relationship with the use of narcotics.
I would like to now talk about the evaluation of Dr. Breathney Barrett. I think you indicated you had opportunity to review his testimony in this trial.
Yes.
And in this trial, he mentioned that there is a difference between a psychologist and a psychiatrist, the main one being that psychologists cannot prescribe medications. Do you recall that?
Yes.
Are there other differences from a professional standpoint based on your experience as a psychiatrist with a psychologist?
They do certain kinds of psychological testing that I don't do. And there is a subspecialty called neuropsychology that tests for brain injury, and I don't do that. But other than that, we have a fair amount of overlap. The biggest issue is I'm medically trained with an MD and prescribe medications when needed.
Now, he said that he met with Ms. McKenzie on 4 occasions. Is that typical for an evaluation of a plaintiff for litigation purposes?
It's not typical of an IME. That's where I was confused by his records if he was the treating doctor or the evaluator. He made it clear that he was the evaluator. But after 4 sessions, he also, according to Ms. McKenzie, said, come back if you need. So that's not typical of an evaluating doctor. Also, he didn't make any recommendations for treatment to her, which a evaluating doctor would.
I think we touched upon this earlier. He had 50 pages of medical records to review. Did you look at the 50 pages that he was relying on in his opinions?
Yes, it spanned from about 2010 to 2015.
In his testimony, he talked at length, and in his deposition testimony as well, about Ms. McKenzie being repressed. What is your opinion on that?
I don't agree.
Why not?
She came forward when she felt she was assaulted. She shared it immediately with the Rangers that she felt it was an unusual situation. She shared it with her sister right afterwards. She, at work, she shared it with a coworker. She talked with HR about it. Ms. Ruiz, she talked with Ms. Lomedico about it and others. She appeared on a radio station about the issue. I did not see her as repressed. Repressed would be someone who crawls into a shell or doesn't want to talk about it, doesn't share it with anybody, and that's where it goes. And then they may get it, they may resolve it, or they may get increasingly depressed or upset because they're internalizing it. That was not the picture that I saw with Ms. McKenzie.
Now, the testing that Dr. Barrett administered, is there any concerns you have regarding those tests other than what you've already told us?
No.
And then Dr. Barrett mentioned that, in his opinion, that she will need, Ms. McKenzie will need years of therapy because of what happened with Mr. Filner. What is your opinion of that?
I disagree. And the reasons I disagree I can give you if you want them.
Yes, what are your reasons?
The timing is off. She has this stressful episode in April of 2013, and I completely agree that it was stressful for her, and it upsets her for a number of months. She has regular contact with her doctor who prescribes antidepressants and anxiety, but doesn't discuss counseling. She doesn't see Barrett more than 2 years later. Needs therapy, and they're showing by their doctor that they usually get within also, she ended the treatment or the, basically I'll call a fine or she has health and she has health access. She could get unlikely that she needs that treatment, and it's unlikely if it were there she would seek it.
Whether Ms. McKenzie counter Bob Filner on April 24th.
I think for a few months she was in the stress from litigation, which is very stressful for you. Her medicine stayed the same. Her discussions with her doctors are basically on her orthopedic problems, and there's no evidence at all that there's any difference in her mental state. There's only one comment on the Filner case in the thousands of pages of sharp records that I reviewed that had to do with her mental state and her medical care.
Questions, tender the witness, Your Honor.
Okay, we will have cross-examination after the mid-morning.